We all remember the travel bans. Brian Peckford, who served as the third Premier of Newfoundland from 1979 to 1989, and who is the sole surviving author of our Charter of Rights and Freedoms, along with others, took the federal government to court last year in defense of our right to freedom of movement. The court dismissed the case, ruling it moot, as the travel bans were no longer in place at that time. This is somewhat akin to ruling an assault moot, because the assault is no longer in progress. The Justice Center for Constitutional Freedoms appealed the decision and lost. In an official statement, the Justice Center for Constitutional Freedoms announced they are disappointed with the federal court's decision in the matter of Yates et al. Versus Canada, a constitutional challenge to the mandatory use of the ArriveCAN app, which was released on July 19, 2023, where the court found no errors in the motion judge's decision that the application was moot. The decision will be reviewed thoroughly, and an update will be provided in due course with respect to potential next steps. The Federal Court of Appeal heard the appeal on June 13th of this year, in which the request was made to review and overturn the federal court's decision not to consider the merits of the case due to mootness. JCCF lawyers argued that a decision from the federal court would swiftly resolve the constitutional arguments that would otherwise clog lower courts, where prosecution of Canadians who did not use the ArriveCAN app are still proceeding across the country. As I've said before in regards to this case, the most likely reason for the courts refusing to hear the case is that our government is planning to bring back travel restrictions.